5 seconds to go. Start. Section 18 of MACOCA, through a non-obstant clause, overrides the mandate contained in sections 25 and 26 of the Evidence Act by rendering a confession as admissible even if it is made to a police officer not below the rank of Deputy Commissioner of Police. Therefore, even though sections 25 and 26 of the Evidence Act render inadmissible confessional statements made to a police officer or while in police custody, section 18 of MACOCA overrides the said provisions and bestows admissibility to such confessional statements as would fall within the purview of section 18 of MACOCA. It is, however, relevant to mention that section 18 of MACOCA makes such confessional statements admissible only for the trial of such person or co-accused, abettor or conspirator. Since section 18 of MACOCA is an exception to the rule laid down in sections 25 and 26 of the Evidence Act, the same will have to be interpreted strictly and for the limited purpose contemplated thereunder. The admissibility of a confessional statement would clearly be taken as overriding sections 25 and 26 of the Evidence Act for purposes of admissibility, but must mandatorily be limited to the accused confessor himself and to a co-accused, abettor or conspirator. The reference in the confessional statements of the two accused persons in relation to the appellant is not a factor entirely irrelevant for the appellant being a co-accused person with them. The detailed discussion by the sanctioning authority to the substantial pieces of evidence collected in the matter rather fortifies the conclusion that the sanctioning authority has meticulously applied its mind to all the relevant factors and has taken an overall view of the matter before forming the final opinion in favor of granting the sanction. The contention in that regard also fails. The learned counsel for the state has fairly and rightly indicated, with reference to the decision of this court in the case of Vinod G. Asrani Supra, that the validity of sanction could always be determined by the trial court during the course of trial, where sanctioning authority could be examined and the appellant will have sufficient opportunity to contest the same, including that of cross-examining the sanctioning authority. In fact, the High Court has also taken care in its impugned order to make it clear that the observations were only prima facie and nothing in the order would influence or prejudice the trial or preempt any legitimate defense of the appellant. In Vinod G. Asrani Supra, this court has observed and held as under the scheme under section 23 of MACOCA, its similar, and section 23 1A provides a safeguard that no investigation into an offence under MACOCA should be commenced without the approval of the authorities concerned. Once such approval is obtained, an investigation is commenced. Those who are subsequently found to be involved in the commission of the organized crime can very well be proceeded against once sanction is obtained against them under section 23(2) of MCOCA as to whether any offence has at all been made out against the petitioner for prosecution under MCOCA, the High Court has rightly pointed out that the accused will have sufficient opportunity to contest the same before the special court. For what has been discussed herein above, this appeal must fail on merits. Stop.